Good morning, everybody, and welcome to Law&Crime. I'm Jesse Weber, joined here on set by trial attorney Bob Hille. We're going to break down some big legal stories that are happening in the news, and particularly a major live trial. So let's break it down right now. Wow. And that was the day they found the remains, and she's ultimately arrested. Bob, you get two different videos here, different in tone, different in questioning. I gotta say, in my opinion, not either of them are not good for the defendant from yesterday. What's your take?
Well, I think the big thing with both videos are going to be, are there any inconsistencies? Because the jury's going to be allowed to reject any of the defense evidence that's related to any her statement she made or any proofs, false in one, false in all. But the other thing is you saw two different people there, which was interesting. When she was telling her story, she was very comfortable. When she was getting pressed, all of a sudden she got very defensive. She stopped looking at the examiners, and you had the feeling that she was getting nervous about her responses, and she was off script now.
Well, I'm also here with criminal defense attorney Lakai Vinson. And Lakai, I guess the question is, if you're put in the position of defending Miss McArthur, and those tapes are played in their entirety, and we just saw what she said, what do you do? How do you say to this jury, well, I know these tapes said one thing, but think about it this way?
Well, not a lot of individual jury members have been put in a position when they're being interrogated by the police, but you certainly want to argue to the jury that her nerves got the best of her. She's absolutely nervous. She has an idea that they have some speculation that she's involved, and so of course she's concerned. So her interview on day one, or her interview during the first set of questioning where she's able to tell her story, is certainly going to be far different when she is interrogated, asked questions, accusations are made. So you're trying to portray a story for the jury that allows them to understand the nervousness under the circumstances as it relates.
Yeah, this tape was fascinating to watch. I mean, at one point, she's like, I don't know where she could be. You know, she visited a lot of other places. She visited Vegas, Tallahassee. There was one part where I thought she was going to say, why don't you just check the middle of the ocean? You know, maybe she's there, giving them all different places to look, and she didn't know anything that happened. So we have these interrogation tapes, but her day got worse because of this. The Home Depot video. Again, I think we have it for you. I want to play it to you. So again, she visits this Home Depot, okay? The items she buys, these potted soil, the cement, this is where the body is found under. It's found underneath the cement and potted soil. She's buying this the day after Taylor Wright goes missing. What do you think?
Well, and this is why circumstantial evidence in cases perform such an important role in the criminal justice system, because as the circumstances tie a defendant to the crime, and in this case, that would be tying her into the crime, that purchase, it lays the foundation for the state's proofs. And then the defendant has to really examine, well, what was I using it for? I bought it. She can't deny she bought it. So what did she do with it? If she didn't use it to bury the body.
Unless it's just major coincidence that the remains are found on her family property and she's buying the very items that are in question here. So Lakai, I guess the question is, for this kind of case, couldn't the defense say, yeah, the prosecution, they have no evidence, you know, where was she, all this. But wouldn't it have been better, or maybe they are going to do this a little bit more, we've kind of seen a flavor of it, don't they have to point the finger at somebody else and try to cast doubt and say, well, there were other people in Taylor Wright's life, and she was going through a lot at the time that she was ultimately killed, that perhaps, jury, you should be thinking about?
Absolutely, Jesse. I think here we're talking about a circumstance where she was undergoing a divorce. There were a lot of issues between her and her husband. So I think they should absolutely point the finger elsewhere and say, hey, there were other individuals who had issues with Wright. This doesn't necessarily mean that McArthur was the one that was involved in this killing. So they need to look at other potential suspects.
Now, here's the thing. There's still a case that has to be put on. But, Bob, here's a weird part about the case that I wanted to talk to you about. The judge yesterday says that she wants this case wrapped up. She wants it wrapped up by tomorrow. She actually asked the prosecution to streamline their case. Why is that? Is that because a hurricane is about to hit Florida? Is that because it's Labor Day weekend coming up? Have you ever heard of a judge asking the state to streamline their case? I don't even know what that means.
You get that in a civil case, but where somebody's on trial for murder, you know, it's different from the outset of the case where you're explaining to jurors for their own purposes, you know, here's how long we think the case will be, the evidence for your own scheduling purposes at the outset of the case. But understand, ladies and gentlemen, you're going to be here to do justice, and it's going to, how long it takes to do justice, you're going to be here for that. It's another thing after the case is going through, in the middle of the case, saying, oh, we're going to finish this, we got to finish this up and get it through by Friday. You know, human nature is not such where you want to sit on a fence. So in a case like this, you know, people are going to start to form opinions about it from the outset. What the judge could be telegraphing by making a comment like that is, well, what's the point in listening to any more evidence? You know, we got enough here. You know, let's wrap this up. And I
That's
think
her perspective, though.
And I
That's
think
not
the
fair for her to do.
Yeah, and I think that the jury could seize on that and say, oh, maybe the signal. Now the question is, does that hurt the state's case or the defense is another issue, but I think it's going to hurt somebody's case.
And if it, okay, so Lakai, let's say it hurts the defense's case, and you could say, look, the prosecution so far, they've put in strong evidence. I wouldn't be surprised if they have enough to present their case. But with the defense, if now they're feeling rushed and they don't get the verdict that they were looking for and she's found guilty, do they have room to appeal that based upon the judge's decision to streamline this case?
Well, we all know as defense attorneys, there's always room to appeal. That doesn't necessarily mean that the verdict will be overturned as a result of your appeal. But if they feel rushed and they don't feel that they have an opportunity to have a fair and impartial jury hear their evidence and decide their case, then there's absolutely room for an appeal, and they should follow through with that.
Well, and what we're looking at here is she is actually represented by a father and son defense team. You don't always see that. We're going to have an opportunity to talk about how they've been doing in the course of the case and what they plan to do as the case continues, as maybe they say they only have one more day to get all this wrapped up, and what a closing argument's going to entail as well. In the meantime, let's take a break, and when we come back, what I would like to do is play some of the openings for you to see how this trial started out. So stay tuned. We'll be right back here on Law and Crime.